Wednesday morning, February 12th, and we're continuing to take testimony on H2. And we're going to welcome a representative from the Department of Public Safety to the table. Thank you for being here, Tucker, and if you introduce yourself and proceed.
Good morning, everyone. My name is Tucker Jones. I'm an attorney with the Department of Public Safety. Just trying to knock anything over here. Hey, thank you for having me in on this bill. And thank you for your work on the topic. I think you're trying to move the issues in the right direction here. And I appreciate the work that the committee is doing to sincerely grapple with some of the kind of concerns that have been flagged with juvenile justice. I really do. So specific to this draft 2.1, I kind of go back to front, if I may. So just starting with the effective dates, those probation violation provisions, they're like section 10 through 12. Under the effective dates, they're not effective until 2027. And so just a flag there, because you may have intended those types of provisions to go into effect earlier. And then, as you probably, it's been flagged already for you, the effective date for the delay of raise the age, it would be 2025, not 2024. So those are just the technical pieces at the end.
Say that again. I'm not sure I follow that.
So for the effective dates, sections 5 through 12 shall take effect in 2027. That includes those probation violation scheme that you have in there. And I assume that you anticipated to have that go into effect sooner rather than a 2-year delay, but I don't know.
No, that was really tied to the raise the age component of it.
To wait for that to go into effect.
That was the concept, and we can certainly hear from folks. But in any event, we've learned that so far at this point, it's unconstitutional, our provisions there. So if there's going to be some sort of other transfer mechanism, we need to work that out.
Sure.
There has been a suggestion that we have that as part of the December 2025 report that we're expecting from a group that we already tasked for looking at transfer issues. But if we can come up with something in the short term that deals with that accountability issue, that gap that we kind of identified, that's great. But then we can talk about whether it should go into effect immediately or not immediately, but sooner
rather than later. Yeah, and
eager to hear the ideas of how we can make that constitutional.
Yes. And then as to the effective dates, 3 and 4, it's March 31st, 2025, not 2024, probably there. With the probation violation scheme here, I think that look, before you even kind of get to those constitutional concerns, and I saw Eric's posting yesterday, but I didn't kind of hear the testimony. Separate from that, this transfer standard to send it back to criminal and the remedy for probation violations to start all over in the criminal division, I think that's a problematic structure. And so, again, I do appreciate the direction that you're trying to go here to fix this gap for the enforcement of noncompliance when it comes to the probation violations. But when we're starting, if the remedy is to just start the case all over again in the criminal division, separate from any double jeopardy concerns or anything like that, I think it is problematic to do the whole case again, especially when we're dealing with cases involving victims that we're going to need to testify, et cetera. So I think it's worth continuing to pursue this, what available mechanisms there are. But I think starting a whole new criminal proceeding and just doing it all again from the beginning, I think it's problematic. The standard, considering the nature of the probation violation and whether it demonstrates that continued family division jurisdiction poses an unreasonable risk to public safety, think we kind of have to sink our teeth in that a little more and what that means exactly. The nature of the probation violation, so I think there's more work to be done on the mechanism there and the standard to kick it out. I don't have language this morning, but these are topics that I think that there may be some more straightforward ways to tackle the enforcement of probation violations that do not necessarily require starting from scratch in the criminal division for a new case. I mentioned last time enforcement of violations of delinquency conditions of release as well. And I was hoping to potentially find some language to tie that topic in as well. And then there's a few other topics that I think are worth clarifying this session. One, clarifying the authority for DCF to take physical custody for those over 18. I've heard different things from practitioners, lack of clarity on the statutory authority to take physical custody of those over 18. The issue remains of where that custody is going to be exactly, whether you have two social workers sitting outside a motel room, whether you have a foster care placement, whether the Middlesex facility, whether the agreement with the provider of that facility can even accommodate those over 18. Those are all outstanding questions, but nonetheless, you have this basic issue of whether you can even have the authority to take physical custody. And I think that could be just a sentence that could be ironed out potentially.
So let me ask a couple questions. Would it be 18 and over, not over 18?
18 and over, yeah.
Right.
Yeah, including 18-year-olds.
Yeah, okay. And I would deeply appreciate someone showing me where the language can be changed.
Yes.
And I will also ask Eric to be looking at that, but if other folks have ideas that would expedite that, because that would be nice to be able to resolve that in this bill as opposed to postponing that.
And then the other thing I heard about, and so I recognize, and we could talk about the timing too, because you have this April 1st deadline for this other piece. So there's this issue of how much longer and spend working through the more thorny topics and the less the topics that have less consensus versus that 18, that raise the age piece, which you got to get out and, you have your timeline to do that. So I'm keeping that in mind in terms of what can be done and whether at a certain point it makes sense to kind of separate those two topics. Because the last one is clarifying the legal authority for DCF to compel those over 18 to engage in treatment or other services. This is something that I've heard from DCF that even if they had the ability to take physical custody of someone over 18, because they're not essentially acting in their parental capacity, they can't compel an 18-year-old against their will to engage in treatment or services. Again, something that potentially could be addressed relatively, easily.
The custody issue?
Yeah, I think there's some distinction to be made, the legal and physical custody. So I just would want to kind of clarify both points, because I have heard the concern from DCF that even if they can actually take that 18-year-old and put them wherever in a foster care placement, if that 18-year-old doesn't want to engage in the services, some didn't believe they had the legal authority to compel it. And again, in certain circumstances, I think it makes sense. Look, why does all of this matter is the bigger question. We've talked about it to some degree. The enforcement of conditions of release, the quick ability to enforce it, the enforcement of violations of probation conditions, the authority to take custody, the authority to compel treatment. Does that matter so much when an 18-year-old graffitis the concession stand behind the bleachers? Not as much as some of these other cases that we have. Now, last time I gave out that list of those cases that aren't included in the Big 12. And the reason that these enforcement mechanisms start to matter is because the conduct in some of these cases does require meaningful rehabilitation, It does require a sufficient period of time to allow for that rehabilitation. It does implicate public safety if you don't meaningfully rehabilitate that youth. And if a youth who engages in some of this conduct is not compliant voluntarily with the orders of the court, the requests of the DCF social worker, you want to be able to answer the question of then what, in a way that is commensurate with the harm, the risk of harm from their behavior. And it starts to matter when we're talking about intimate partner domestic assault, aggravated domestic assault, lewd lascivious conduct with a child, possession of child sexual abuse materials, carrying a dangerous weapon while committing a felony. These are the offenses in which we really need clear answers to the then what when you have noncompliance.
Karen.
I see the space with the more serious crimes of the desire to have some type of intervention and follow up with it, rehabilitation. And I guess I'm trying to understand. So what I'm hearing is that there would like to be a requirement for it. Like somehow, how are you making them go through with it? Which I'm struggling with because in the criminal system, there isn't a way to mandate it.
Well, it's interesting because this implicates similar conversations we're having on, revocation of bail, et cetera, in the criminal realm of what is the backstop when you have persistent noncompliance. And typically, really the backstop within the criminal justice system is at some point custody. And the same principles kind of apply here of at what point is the public safety risk of, caused by the noncompliance rise to the level of, the need for actual custody. And that's why I want, I'm flagging like we got to have clear authority for custody, statutory authority. There's got to be a place of where that custody can be. And it starts to matter when you have someone who's taking a substantial step towards a mass casualty event like a school shooting, and that's interrupted. You need the mechanisms at that point for that type of conduct in which you can have a secure custody when needed, and you can ensure that you have the mechanisms in place to quickly enforce violations of conditions of release and enforce the probation violations. The concern with the current delinquency structure that I've gotten, from the DSAs and from the social workers is that we don't really have those mechanisms in place. And so as an example, I gave the example of the probation violations where one DSA was saying to me that, well, they can seek a bench warrant to bring the youth into the court and have the court reprimand the youth to listen to the social worker. And then that hearing is over and they all leave. And then a few months go by and that social worker will come back to the deputy state's attorney and say, this person hasn't been returning my calls. This person, they're not engaging with me. And so they go through the process again. The problem is if you drag your feet long enough, you get to the point where jurisdiction evaporates at some point within the delinquency realm. And so then you do have people who can fall through the cracks where you don't actually have the meaningful rehabilitation that is really necessary when you're dealing with these serious cases. That's the example that I got from one DSA on the issues with enforcement of probation violations. In the conditions of release, the example I got from one DSA is that he felt he could not in good conscience file a aggravated domestic assault as a delinquency when you actually had intimate partner violence with these young people, because he believed that with the delinquency conditions of release, he could not adequately protect the victim from ongoing contact from the perpetrator. And so he's just saying that he didn't feel like he had the tools available in delinquency conditions of release to address the risk of violations of conditions of release from that youth, and so felt that he actually had to file this as an aggravated assault in the criminal division because that is one of the big 14, but in fact, it was a domestic.
So can I ask you a question? Was that like What was the age group in that consideration? And when we're talking about that backstop, can you distinguish between 18-year-olds and under 18-year-olds?
Yeah, I don't know. I'm not sure if he said the specific age from that example that he gave to me. When you're dealing with younger people, if it's someone who's 16 and they have clear authority for custody in that scenario, DCF custody, then you have a better situation. The problem is if that custody is at a foster care placement and you have some of these foster care homes which take the teenagers in particular, like several teenagers they'll take in. If the level of risk from the behavior is so great, you're really relying on a foster care parent to monitor the behavior of that youth. That's why they're trying to get the Middlesex off the ground, and that's a DCF operational thing. It's outside of
And that's the red clover.
temporary, facility as a stopgap, I believe, until they have a more permanent facility. This is why the permanent facility, matters in this scheme, because these cases do happen with some degree of regularity. And you got, again, if you have voluntary compliance with the young person, that's great. But if you have some combination of high risk behavior, high risk misconduct, plus non-compliance and lack of interest in listening to literally the adults in the room, which happens with teenagers. That's the problem. They don't necessarily want to listen to the adults in the room. You need an answer to the then what? What are we going to do? And one of the issues with the conditions of release for the delinquencies, the concern was the timing of their ability to enforce violations of that did rise to the level of, contacting the victim, and whether they really had a quick enough remedy in the delinquency scheme to tackle that. Anyway, so that is, those are kind of the considerations that I have gone forward.
So I'm just trying to understand the goal of this, because I'm hearing a couple different things with it. Is the piece of wanting to rehabilitate, like I'm hearing that piece of it, but then I'm also hearing the backstop piece, and I feel like they might not be in line with each other, because there are pieces with the criminal justice system where, like, you can only hold people for so long. If they max out their sentence and they haven't completed rehabilitation and done that work, like ultimately they get to go. And so I'm trying to see that parallel with that's just how the system works sometimes, is you provide all the opportunity, you hold them, and then it's off to them to go out and be back in the world. And if they commit another crime or delinquency, then they come back to the system. And I feel like that's in the criminal justice system too. So I'm just trying to understand what the goal is that you're trying to get, that you want to have more backstops, you want people to be rehabilitated.
The way, in my experience, I told you, I used to do these cases years ago now at this point. One of the things that I always took away from dealing with these delinquency and YO cases is that these young people, the perpetrators of these offenses, but also the victims, they're entering into the system and they're learning lessons. And they're learning lessons fast. They're smart. They're very smart young people. And they see what happens or doesn't happen. And they walk away from that with lessons learned about whether there are consequences for their behavior or not. And I think one of the concerns that Massachusetts study was getting at, of actually seeing an increase in recidivism, which was measured as subsequent court involvement. Mm-hmm. It was specific for those who had no prior court involvement in particular. And there wasn't as much as an increase, or there wasn't an increase at all for those who had prior court involvement. And in my experience, one of the things that may be happening there is those young people are learning a lesson that you can get away with it. And the problem is that when they're then 23 and that someone owes them money for that drug transaction, they have this confidence that they can then bring a firearm to that front door, shoot a gun through that front door at 20, in their 20s, and having not learned the lesson when they were 18, that you can't do that, you know? And now we're talking about attempted murder for a 23-year-old being held without bail in an adult correctional facility. And in my best judgment, the system has failed that person because we lost the opportunity at 18 to really teach them the important lesson that you can't steal someone's car, flip it, and get away with it. And because they didn't learn that lesson then, we have this situation where that person is probably still in jail. Their life is certainly, you know, not going in a great direction. But in a way, it was one of those iatrogenic harms where we inflicted that on that young person. So that's where I come from of the backstop is teaching them the lesson now of like, look, if you then contact your intimate partner after we've apprehended you for, you know, threatening serious bodily harm, something's going to happen. You know, we don't just let that fall through the cracks because we're trying to take care of you now, teach you that lesson now. Now, the same thing about lessons learned, it applies to the victims of these cases. When we have sexual misconduct cases with these young people, there are victims to those who are often young women in our school systems. I've dealt with those cases and I've seen young women walk away from this system, the juvenile justice system, with an extraordinary level of frustration about the, you know, lack of accountability that they have seen happen and the strong feeling that that young man got away with it. And that's a lesson that she is learning at age 16. And so they're learning lessons on both sides. You want to ensure that they're learning the right lessons, you know? And when we're taught, that's why I raise these listed offenses, the additional offenses, because that's that type of conduct. You really want to make sure that you're addressing the what then when they don't voluntarily comply with the request of the court, the request of the social worker, and that you actually have that backstop built in. I think there are some relatively straightforward this session, you know, language that can address some of that. And I'm, you know, I'll work on that. I'll work on that because
Is that for the under 18 age? Because, you know, I've been focusing more on the 18 and above. But my understanding was that DCF can take custody. DCF has the limited ways to take custody. That the Green Mountain Youth Campus, which is a terrible name for that, is going to provide additional ability. So, but
I'm thinking 18 plus.
okay, yeah. So that's the kind of, because that's where I've understood we're really trying to focus our fix.
Yes, that's where we run into those where we're talking about adults
And we don't have a
who are
place.
living together. You know,
We don't have a place
yes,
because Red Clover is not.
it's my understanding as well, is that agreement is limited to those under 18. I don't know that world as much, the TCF does. So anyway.
I just want to clarify that. Thank you.
Yep. So that's pretty much it. So in general, you know, I think that probation violation scheme, starting all over in the criminal division, I don't think that makes so much sense. But I do think that there are some straightforward ways to kind of get at those specific points on what do you do to enforce violations of delinquency conditions of release somewhat more effectively and more timely. What do we do to enforce probation violations like this scheme, but that doesn't require starting from scratch in the criminal division for this older age cohort, clarifying the authority for DCF physical custody, legal authority over those over 18 to compel treatment when necessary. And, you know, you do extend the jurisdiction here.
Well,
Yes.
Two, right? Barbara, I think,
Sorry.
unmuted, Barbara.
Zoom here.
Barbara, if you could mute, thank you. All right. Back to you. So yes, that's section 2 you're referencing now, I believe.
Yeah, I mean, I think that's key because I don't know how long it takes, like what the average length of time is to adjudicate a felony delinquency. But if you're 18, say you're 18 and a half as an average age, and say it takes 12 months to get to adjudication and disposition in a delinquency. So now you're 19 and a half. You know, the current law was you lose jurisdiction at 20 and a half. Now you extend that to 21 and a half, I believe, in here. But you can see how that 20 and a half, like we're asking for 1 year, you know, once you actually get to adjudication, you're asking for supervision for probation for 1 year. And some of these offenses, I can't, you know, we're talking very serious conduct that I think extends beyond that. So it's a step towards that, though, in this bill that you're saying, okay, now you're talking 2 years by the time you get maybe to adjudication disposition. Maybe that time frame to get to adjudication disposition, that was just a tentative guess. I don't actually know the kind of best estimate from those who are practicing today, but you need a sufficient period of time for meaningful rehabilitation from the time of disposition, you know. And one of the real concerns with the delinquencies with the older youth is that, you know, you'd be getting your hearing on that probation violation, and you got 6 months left of jurisdiction over this young person, and there's some degree to which that was, you know, there's some consternation over that, and this was the age out issue. You know? So you take a step in the right direction there.
Okay.
So two questions, and on the data piece of things. So you mentioned before that some of these, more aggressive, cases, juvenile cases happen to a degree of regularity. And that, I think you're specifically talking to the accountability. So curious for the data source on that, or your definition of degree of regularity. And then the other thing I'm hearing is, I feel like there's an assumption that if these folks were in the criminal justice system, there would be more accountability and that there would be more positive outcomes. And I'm looking for the data that shows that that is true, because I'm worried we're creating a system based on these stories or anecdotes, but we're not addressing the larger issues.
I acknowledge, you know, that there's a difference between these high risk behavior with the very serious offenses combined with non-compliant, you know, 18-year-old at the time they commit it. But it is you know, the point is that I'm trying to making is that the system has to be able to account for that scenario because it is not a theoretical scenario. You know, I was a deputy state's attorney handling juvenile matters in Middlebury, Vermont, and I have had plenty of these cases where, you know, everything I was saying today is real case, you know, that I dealt with.
I guess I'm just trying to understand the numbers of it because everybody's a different definition of degree of regularity or plenty. Like what does that look like?
And the problem is, I don't have those numbers. And as far as I know, I don't think we had great numbers from DCF either on some of this. And so what we were relying on was the feedback that we were getting from the social workers in the field and the DSAs in the field for them reporting, hey, look, you know, whatever county they're in, this is the proportion of age outs I have. We did have that proportion of age outs from one of the counties, and the DSA in one of those counties had the proportion. But we didn't have those statewide number of age outs. And in part, I think that was because DCF working on their IT system for coverage of this. But just because we don't have that number doesn't mean that it's not something that needs to be addressed, you know, from the feedback that we're getting from the field. So it's not, you know, it doesn't make the problem go away per se.
Yeah,
you know?
I would, for me, it's just this piece of, so it sounds like data is a piece of what we need to be addressing here. And I just want to be consistent with our use of data, that it's not just leaning on data when it works for us, but also being like, okay, we need data for this to address it. So just being consistent with the need.
I know, I appreciate that. I do, for sure.
Tom.
I don't know if this is really This kind of data related, I don't know if it's a question or a statement or something, but the one thing that sort of concerns me is, as someone is getting older, going from one system to the next, what's the likelihood that the crimes that they're involved in become also at that time more serious? And then you have less to do. I think that's something I'm jogging.
Yeah. Well, the example I gave of showing up to enforce the drug debt with a firearm, that was a real case. And at that point it was, they're old enough and it went into the adult system. So you do see that. And again, I chalk it up my own judgment, but I was working in this system. My own judgment is it was we lost the state. The state really lost. The state failed that young person, actually, because they could have learned. We could have gotten through to them, but we really didn't have the ability to say you have to listen. This isn't a voluntary thing. And that's why I kind of, yeah.
Do you have any viewpoint on the section 13, the attempt to address the so-called ping pong effect? And if you don't, that's fine. I just want to make sure we've covered everything.
Don't have a strong opinion on that.
Okay, and that's fine. We have other folks who do have strong opinions on that. So, any other questions? I'm assuming that you've covered everything.
No, thank you. I mean, I'll say this. This is in the context of this bill. There are other issues with juvenile justice, right, that are beyond this. All of this is specifically as it relates to delinquencies. How, what's happening in our youthful offender world is, I think, worth close legislative scrutiny to really understand that. There is a proposal to restructure that. And again, I think there is value in understanding how the system is handling these serious cases, the list of offenses that I laid out last time, because you really do need meaningful rehabilitation in those cases. And you want to make sure that, DCF has the tools to actually get through to recalcitrant young adults who don't want to listen to a DCF social worker and really answer the then what.
Appreciate that. Thank you.
Thank you all. Appreciate it.
So we'll hear from Judge Zone, and I do have to take a break at 10. And I know we're losing at least one member at 10 as well.
Right.
Yes. So just to jump ahead real quick, you don't really have to tell us how unconstitutional those sections are. But if you have any view on this issue that was raised, and we heard a little bit yesterday from Marshall on custody, on the ability to take custody of 18-year-olds, if you have any view on that, that'd be great. But over to you, and I'll let you just.
I'm Zone Chief Superior Judge. I have. You keep saying this unconstitutional. Is it unconstitutional to you?
He can't tell us.
I can't tell you, but something tells me that you've heard from a number of people about the issue that has arisen when you've been adjudicated as a delinquent. And that's a final adjudication and then transferring it. But I think the Supreme Court in JG may have discussed that topic.
Yes.
So really what I was looking for is that was a policy decision.
No, it's not a policy. It's a constitutional interpretation by the Supreme Court.
Not what I was looking for.
A lot of this bill is policy. I haven't really considered the issues of the 18 or what. I didn't listen to Marshall's testimony. What's his?
The concept is that it's not clear that DCF can take custody, physical custody or legal custody of somebody who's 18.
I would concur with that assessment.
And apparently 49 other states in their juvenile justice type system do have a way or are able to take physical custody of 18, 19-year-olds. Not clear about legal custody. We want to look and see if that's the case and how we would change our statutes to allow that. If that is one of the big issues as far as having a backstop for 18-year-olds who are in the juvenile justice system.
I have not studied that issue, but when you say it, I mean, my initial reaction is that DCF is 18 and under 18. And so my inclination is that that is problematic. I would have to look at the statutes to try to come up and see, where that derives from, and if there's statutory changes that need to be done to effectuate that. If that's the policy, that certainly could.
If we go down that road, we'll have you back in to comment on any language we come up with.
The majority of the bill, again, leaving aside the sections that you've already taken off the table, is issues of policy. And so those are matters for the legislature to determine. One of the questions you just asked to Mr. Jones had to do with that, to get rid of the ping pong effect. I think there's a better way to do it. And there is a committee studying that. I don't know that it works quite as well to try to put it in just that one section with that line. I think it needs more. And I think it actually should probably be moved up a couple sections, because this talks about after the transfer hearing. I think it should be really made very clear that when you're having the transfer hearing, the following is on the table. And so I don't know that it works there as phrased.
Okay.
I do agree that the committee that's looking at these issues for transfer will have these issues to look at. And with the report, I can tell you that it's going to be looked at because I'm chair of the committee. So that is something that is being addressed. Representative Dolan asked about the backstop, and that is an issue that I know the legislature has to look at and say, well, what happens if someone violates? Well, what happens if someone violates is that the legislature has enacted statutes and the courts apply those statutes as enacted. The statutes don't permit the court to just take someone and say, oh, you're on delinquency, you're going into jail. You're going to be held because you need to be taught a lesson. That's not the statutes. That's not the law in the state of Vermont. There are concerns I certainly understand about, well, what is the backstop? Is it working? And it seems to me that that's one of the reasons why it's important to maintain robust transfer proceedings and the ability to transfer, because you don't want to put someone in, whether it's as a youthful offender or otherwise, into a situation where they're not amenable to treatment and they're not going to receive the treatment they need to address their behaviors at their young age. And so it seems to me that what you have the ability to do with those types of provisions is keep out the people that should be problematic and maximize the people, the youth who are going to hopefully benefit from that procedure. Are there going to be times where someone receives that treatment and it doesn't go well? Yes. We recognize that, and we certainly try to address that. But the reality is that before it goes to YO, there are procedures that we engage in, and there is an analysis to say, do they make it? Do we think they have the potential to be successful? Delinquency is different. The question is, do we take it out of here? Can it go out of here? But we do have transfer procedures for those cases to see up front. But the transfer after the horse is in the barn, if you will, that's not something that's out there.
Well, that's where you get into the trouble of that causes this to be unconstitutional, right? I mean, if you've already done the adjudication, you can't do the transfer back to criminal court.
According to JG.
Yeah. So I want to ask you just a little bit about timing and the risk assessment that is done. So it's my understanding, the risk assessment's optional in the delinquency realm, but required in YO, or am I misremembering that?
I thought it was required.
So timing wise, that happens before an adjudication, correct?
Correct.
And the risk assessment is often used to determine if somebody should be sent to diversion.
Correct.
Is that a tool that we could rely on to decide that actually we should transfer this person to criminal court?
That risk assessment?
Yeah. Is that something that's done currently, or is that something that is feasible?
I don't think that we should have a system that says you automatically go to X or Y based upon this risk assessment.
Well, I think there'd still be the transfer
Criteria.
The criteria.
Okay, as long.
But it could trigger actually going through that if the risk assessment comes out that high risk, it automatically goes to a hearing for transfer.
As long as the court maintains the ability, and the state and youth council maintain the ability to give the court full information as to the info that's going to need to determine whether transfer is appropriate under all the factors, that's a factor. And if the legislature as a policy says that it wants to, if you will, take a closer look at, if someone rates X on the assessment, we want to take a closer look at that. Again, as long as we are going to follow the statutes that allow us to take the full look at it, that would seem to be a procedure that is one you can consider.
Yeah, Karen.
So I'm gonna articulate my question in my head, like, and say it at the same time. So, it's around data and it's around this piece. Because I'm hearing you say that an important tool that exists is this transfer, going back and forth, which that's what I've seen too. It's like, okay, so you put the person and if it's not, like, you have the ability to transfer them to a higher or lower degree of the system. And so I guess I'm looking for data of when it goes wrong, right? It's like either they got into, maybe didn't put them in the right system and now they can't be held accountable. Is there data to do that? Because I am just worried that we are creating a system that is really focused on those folks that are not working in the system, those kind of outliers, versus creating a system that works for the majority of people. And I think we would all agree, like, the criminal justice system is that way too. Like, we try to make it work the best, but then there's folks that are going to be outliers on it. And that's just a reality of it. So I'm wondering if you have data that can help us see, like, how many people is it that, okay, they're in the juvenile system and they're not being held accountable. You know what I'm trying to say?
Well, I think one of the questions that comes up is, how do we define accountability? I would suspect that around this table, each of you has a different view of that potential. Is accountability that you are held to the standard of the law? That if you do X and the law says that here are the options that the court has to address that, is that accountability? I suggest it is. That's the law. If accountability is, well, we think someone who does something, we don't think that the law is adequate to address that behavior, well, I think that's something different. Is it accountability? Absolutely. But I think it brings up a different question. And so when we look at the data, there could be different sets of data potentially. And I haven't asked our data people about this. One set could be, how many people have had violations? And did they stay in a delinquency or YO status after the violation hearing? And then how many people have had violations and have gone up? Then the question is, okay, for those who stayed in, was there recidivism? I don't believe we track that necessarily. For those who went up, was there recidivism? And so I think we start getting, the more we start looking for that data, the more we find out that there's a lot of individualized nuances that we're not going to be able to capture. Because the individual who was, let's say, stayed in delinquency proceedings and had violations, and you touched on this with Mr. Jones too. It may have been that the time expired and they didn't get it. As you said, there are times where someone can just not do what they're supposed to do when they go to jail and do their time and move on. So we don't know if those individuals timed out, if you will, or got the help they needed to not engage in further bad behaviors. But I can look into that, but I don't think we're going to be able to have data that really nails that.
Well, I think as follow-up, we'll probably have Robin Joy, who knows data as well as anybody, come in and talk to us a little bit about data that the court has, that NIVERS has, whatever other sources, try to get a little better feel for that. So yeah, we'll do that, definitely.
I can make one.
Yeah.
Just a question, no, a comment maybe, that you were just defining accountability. And I want to say that, because that was, that was the question asked, but, I think it's important to remember that the stated goal, the statutorily stated goal of the juvenile justice system is rehabilitation, which I think is different, probably includes accountability. but it's a different measurement. It's a different metric, I think, and one that seems to be getting lost in some of this conversation. So I'm just trying to fill it back in.
I will not agree with everything you said because some of it's a policy or a comment. But I will agree that accountability is part and parcel of the entire statutory framework, that it is part of the rehabilitation process.
And I think that the, chapter 51 or 52 gives a long list of what is the purpose of juvenile justice system. Rehabilitation is one, accountability is another, and there are several other listed. So, yeah. Any other questions, or do you have more comments on any other?
No, I think it really, again, a lot of policy. I think that when you're looking at the transfer, it is critical to make sure that the cases go to the right court. And if there are concerns about individual behaviors, look at those types of behaviors, look at those types of cases, and make sure that it gets on the right road.
I appreciate it. Thank you very much. And when we have a next version of this, which we almost certainly will, we'll see if you still have any more comments on it.
So see you tomorrow. Thank you.
Thank you very much. We'll see you via Zoom tomorrow because of all that snow. So we will go to Susanna, and I am going to have to duck out to go present a bill next door, and Ken will take over as far as at that point. So Susanna, if you're available and can get started, if you're there we are. Thank you for being here, Susanna, and I apologize that I am going to have to just step out, but Ken, I'll leave it in the capable hands of Ken for any questions and continuing on. So.
Thank you. Yes, actually, for the record, Susanna Davis, Racial Equity Director for the state. Actually, my testimony is quite brief today. I just wanted to highlight two particular points regarding the newest version of the bill. The first is we do note that there has been a delay on the Raise the Age piece to 2027. And we just really want to echo the testimony you heard from the Child Youth Family Advocate about making the best use of that time by supporting DCF with the staff necessary to ensure that we can actually manage that caseload once 2027 comes upon us. The second thing that I wanted to say was our staff identified a question about the fact that in this bill, when we reach that date, the provision will only apply to new proceedings, beginning at that time going forward. And so for us, we are concerned / curious about whether there will then be two classes of youth who are of the same age and simultaneously in the system, but being treated differently based on whether they're from the before time or from that point in 2027 going forward. So just thinking about parity. It could be that I'm misunderstanding it, but if I'm not, then I think we're going to want to think about parity and in what ways we're creating any kind of disparities. And those disparities may not necessarily cut along any particular demographic lines at all. But still, if we're having those two clusters, then that was a question that came up for us. Otherwise, I think you've heard fine testimony so far on this draft, and you will continue to. Ultimately, I think our office just wants to remain vigilant about the downstream impacts of any of these changes. And we're looking forward to making the best use of whatever data come out of it to make sure that we're not creating any unintentional disparities. That's actually it from me. Thank you. Any questions that you all may have, they're welcome.
Yeah, I appreciate that. Just on that second concern that you have, just so you understand why that is in there. One is there was a concern from DCF when we were talking about April 1st that all of a sudden they would have 115 additional cases just all at once, as opposed to it being spaced out. The second is that those individuals have already lost one of the main benefits of the juvenile justice system, which is the confidentiality. I do understand that the fact of a criminal record still is a disparity there. But that's why that provision's in there, just so you know the rationale. But I understand where you're coming from as well.
That made sense to us. It reminds me of the way that we approached the use of the impact assessment tool, where we made it mandatory for new budget or policy proposals. And our intention had always been to go back once we gained confidence and a rhythm using the tool, that we would then go back and use it on existing policy. I would say that, so I definitely understand that. And I think that if we do move forward with this approach, then I want us to not forget the people who are in that existing protocol. I know we can't because we have them, so it's hard to forget people you have, but transitions are just difficult. I think some of these questions, there may not be a right answer, and transitioning from one system or approach to another means that there are some things that will fall through the cracks, and I know that you all are committed to those things falling through the cracks not being people.
So I think just from what you've said, I think one of the things we're going to probably add to this is a reporting requirement, much like the reports that have been done on every other month. You know, we'll have a little space, but we can actually task DCF with providing us a transition plan to address that kind of situation where all of a sudden there could be 115. Maybe there's a process for moving some of those while others stay put, and that's the kind of thing we can have them look at. So I'm glad that you pointed out that concern.
Thank you so much. Can I just say one thing, because I can't help myself? If you do ask for a transition plan, I would strongly encourage the committee to include language in there that requires, or at least strongly encourages, the department to seek community input early as part of its process in creating that transition plan, so that we can make sure that they're hearing from people who are going to be most impacted. And when we recommend that working groups or anybody in government convene the community to hear its feedback, it's always helpful if there is even a very modest budget that allows for that, even if it's something as simple as fee for space, translations, stipends for people to be able to get to whatever sessions we're talking about. It always helps to be able to receive meaningful feedback from people with lived expertise. And I think that if we're thinking about creating systems that will lend themselves most to rehabilitation, people are more willing to participate in good faith in things where they feel that they have some ownership of the process. And so the community being able to see itself reflected in something like a transition plan, I think, could go a long way to demonstrating a good faith effort on our part to give a sense of ownership of the process. So I would encourage the committee to think about including language about seeking community input if you do seek a transition plan from the department.
So have you suggested language like that for other situations? And if so, can I have our legislative council reach out to you or somebody in your home to get that kind of language?
Yeah, we'd be happy to provide some language.
Okay, great. Thank you very much.
Thank you all.
Any other questions? Thank you again for being here. That's very helpful. And we will take a break till quarter after, which time I think Ms. Van Steen should be available as the next one. We'll have Kim after that.